A man, Ethan, opens a certified letter. Inside, a legal summons, pages heavy with the scent of cheap toner and expensive spite. His jaw tightens, but a flicker of grim amusement crosses his face. Voiceover, Ethan Steele. They tried to fine me for owning the future. They thought their 3-ring binder was the law. Quick cuts, a highly polished shoe stepping onto a lush green lawn. A close-up of a venomous, satisfied smirk. HOA President Gerald Thorne. HOA lawyer, straining, desperate. A blatant and persistent violation of community aesthetics. The camera focuses on the judge's bench where the Honorable Roberta Wells lowers her head, shaking it slowly. Her shoulders begin to tremble, not with anger, but with an attempt to suppress an utterly incredulous laugh. They didn't realize they'd just signed the declaration of their own. The metallic scent of ozone was the first thing Ethan noticed. A faint, clean smell that mingled with the humid late August air as the sun dipped behind the meticulously uniform rooftops of the Azure Cove community. The sound was a low, steady thrum, the heartbeat of his new life, quite literally fueling the midnight silver Tesla Model S parked neatly in the garage. He'd spent 6 hours installing the wall connector, a piece of sleek industrial design that looked less like a power source and more like a minimalist sculpture. It was positioned exactly where the old clothes dryer vent used to be, tucked away inside the garage, out of sight. No one, he'd thought, not even the most hyper-vigilant member of the Homeowners Association, could possibly take issue. Ethan Cross had moved to Azure Cove for the tranquility, not the compliance. After selling his software startup, he sought silence, not the suffocating homogeneity mandated by the covenants, conditions, and restrictions, CC&Rs. The rules were tedious, but he had read them. He'd read every clause, every footnote, every Byzantine regulation concerning mailbox heights and acceptable shades of beige. Nothing, absolutely nothing, prohibited a standard professionally installed electrical fixture inside a private garage. He was wrong. Dead wrong. The notice arrived 2 days after the installation was complete, tucked beneath a fake peony wreath on his front door. It wasn't a gentle warning. It was a punitive declaration. The envelope was thick, embossed with the Azure Cove HOA logo, a ship's wheel rendered in pretentious gold foil, and addressed personally to him. Ethan R. Cross, Violation Notice. AZC 207A. The subject line was underlined 3 times in red ink. Unauthorized exterior modification and safety hazard. Article 7, Section B, exterior appearance and permanent fixtures. Ethan stared at the $500 fine attached to the first violation. He wasn't bothered by the money. He was bothered by the sheer, unadulterated gall of it. The Charger was inside his garage. The only exterior evidence was the car itself. He didn't call the HOA office. He called the man whose name was stamped on the bottom of the notice, the HOA president and undisputed monarch of Azure Cove, Gerald Thorne. Gerald Thorne lived 3 doors down. He was a retired commercial realtor, a man whose entire personality seemed molded by the oppressive weight of the phrase, perceived property values. He answered on the second ring, his voice smooth and instantly condescending. "Thorne!" he barked. "Gerald, it's Ethan Cross. I just received a violation notice regarding my electric vehicle charger." "Ah, Mr. Cross, the rogue installation," Gerald sighed, a sound calculated to convey the vast disappointment of a superior intellect dealing with a slow student. "I was hoping you'd show some initiative and remove it before the administrative fee was levied." "Remove what, Gerald?" "The charger is secured to the wall inside my locked private garage. It's no different than a new water heater or a washing machine." "Nonsense, Ethan. This is not a utility. It's a permanent fixture that interfaces with the external community grid. And it is frankly an eyesore to the aesthetic integrity of the street. Even if unseen, we know it's there, don't we?" Gerald paused for dramatic effect. "Furthermore, the board has discussed the fire hazard these batteries present. You're increasing the risk for the rest of us." Ethan gripped the phone tighter, fighting to keep the tremor of disbelief out of his voice. "Fire hazard? Gerald, it's a standard 240-volt circuit installed by a certified master electrician approved by the county inspector. I have the permit right here. It's safer than the decade-old circuit breaker panel in your own garage. The county permits do not supersede the CC&Rs. Mr. Cross, our documents explicitly state, no exterior or permanent internal structural modifications may be undertaken without prior written approval from the Architectural Review Board. You submitted no plans, received no approval, and now you are fined. End of discussion. Remove the device within 7 days or the fines double, and we start accruing legal fees. You are going to levy legal fees for something that is legally permitted by the state and county and is not visible from the street? We are going to preserve the community, Mr. Cross. Don't mistake our efficiency for apathy. Gerald hung up without a farewell. The fight was no longer about the charger. It was about the line. Ethan could have paid the fines, unhooked the charger, and hired a lawyer to fight it, slowly, expensively, and privately. But the mention of the fire hazard and the dismissal of the county permit struck a deeper nerve. Gerald wasn't enforcing rules. He was exerting control, inventing danger, and dismissing legal authority on a whim. That evening, Ethan called his friend, Daniel Dan Rhodes, a sharp, young lawyer who specialized in municipal and property law. Dude, $500 for a car charger inside your garage? Dan's voice crackled with professional outrage over the speakerphone. That is textbook overreach. The law is pretty clear on solar and EV charging infrastructure in this state. HOAs cannot unreasonably restrict installations. He's using the permanent internal structural modification clause. He's arguing the electrical wiring running from the main panel is the modification. That's semantic garbage. The wiring is ancillary to a fixture. Did you pull a permit? Yes. Every T crossed, every I dotted. Good. Pay the fine, but include a letter stating you pay under protest and reserve all rights. That establishes your intent to fight the principle, not the fee. Then, submit a formal request for an architectural review detailing the installation. Force their hand. Make them put their frivolous objection in writing. Ethan followed the advice, sending a check and a certified, sharply worded letter. He submitted the permit, the wiring diagrams, and a professionally drafted request for approval. The response, 3 weeks later, was chillingly efficient. The Architectural Review Board, i.e. Gerald and his 2 rubber stamps, voted unanimously to deny the modification. The accompanying letter, signed by Gerald, escalated the rhetoric. It cited unmitigated fire risk, potential for electromagnetic interference with common area security systems, and a significant deviation from the intended residential purpose of the garage space. The fines continued, escalating from $500 to $1,000, then to $2,000. Ethan's mailbox became a daily source of bureaucratic malice. The breaking point came at the monthly HOA board meeting, held in the stifling basement community room. Ethan attended, wearing a crisp shirt and an expression of dangerous calm. The agenda was the usual litany of petty complaints: a slightly overgrown jasmine vine, a rogue blue recycling bin left out past 7 a.m., and then the matter of Lot 207A, the unauthorized electrical installation. Gerald Thorne stood at the podium, a man born to be in front of a badly lit audience. He wore a navy blazer and an air of suffering martyrdom. And despite multiple warnings and accrued fines now totaling $4,000, Mr. Cross has shown an alarming disregard for the safety and fiscal well-being of this community, Gerald announced, his voice echoing slightly in the low ceiling. A few elderly residents murmured nervously. The fire risk claim had clearly landed. Ethan stepped forward. Mr. Thorne, with respect, I need to address the board on the claims of fire hazard and aesthetic deviation. Gerald cut him off with a raised hand, condescendingly slow. You've had your chance to comply, Mr. Cross. The matter is not open for debate. The board has formally denied your retroactive request. The board has made claims that are demonstrably false and slanderous. Ethan shot back, his voice rising, cutting through the murmurs. I have the county fire inspector's letter right here, certifying the installation is up to current code. Furthermore, the National Fire Protection Association explicitly states that proper EV charging is safe. You are using fear to bully a resident, Gerald. We are using common sense, Ethan. A woman named Carol, Gerald's chief lieutenant on the board, chimed in, her face set in a permanent mask of neighborhood grievance. The garage is for parking cars, not running a commercial energy operation. What about the load this puts on our community grid? We're all paying for your electric toys. This was a new angle, the utility cost. Ethan scoffed. The utility company meters my usage, Carol. I pay them directly. The community doesn't pay for a single watt I use. This entire argument is based on ignorance and an abuse of power. Gerald slammed his palm on the podium. That is enough. You are out of order, Mr. Cross. The board has moved to the next phase. We have exhausted our internal resources. He leveled a gaze at Ethan that was pure, unadulterated entitlement. This is a clear, willful violation. We cannot allow residents to decide which rules apply to them. The board has voted unanimo. The complaint lay spread across Daniel Rhodes's massive, reclaimed wood desk, looking less like a legal document and more like a ransom note. $45,000 in projected legal fees. The HOA's counsel, a firm named Sterling and Pierce, was known throughout the county for their aggressive, scorched earth tactics in property disputes, a choice that screamed intimidation. This is not about an appliance. Ethan, Dan said, running a highlighter over the fee schedule. Dan was young, sharp, and wore the kind of expensive, slightly rumpled suit that suggested long hours and a high billable rate. This is a strategic lawsuit against public participation. They know the average homeowner folds when they see numbers like this. It's an extortionary tactic to force compliance. Ethan leaned back in the worn leather chair, the anxiety a cold knot in his stomach. He wasn't poor, but $45,000 was a serious hit, especially just to fight for the right to charge his own car. They're demanding an injunction to enter my property and remove the charger. They're treating this like a hazardous waste spill. That's the core of our defense, Dan countered, tapping the desk. They have to prove two things for a preliminary injunction. One, that they'll suffer irreparable harm if the charger stays, and two, that they have a substantial likelihood of success on the merits. We're going to obliterate both points. Dan flipped to a heavily bookmarked page in the Florida statutes. First, the law. The Florida Renewable Energy Source Devices Statute, Section 163.04, the one you tossed at Gerald, is our silver bullet. It clearly states that an association may not prohibit or reasonably restrict a property owner from installing an EV charging station within the boundaries of the owner's property. And Gerald's argument is that his CC&Rs supersede the statute, specifically the Permanent Internal Modification Clause, Ethan noted. That's where the unreasonably restrict part kicks in, Dan explained, a predatory glint in his eye. A non-visible charger installed to code is demonstrably not an unreasonable restriction. We hit them with the statute, and then we attack their claims of harm, fire risk, aesthetic offense, electromagnetic interference, as being arbitrary, capricious, and manufactured. Ethan nodded. The fire risk claim is easy to refute. I have the permit and the inspector's sign-off. The aesthetic claim is absurd. It's inside a closed garage. But what about the electromagnetic interference? That sounds like pure nonsense. It is, Dan said, his voice dropping to a conspiratorial whisper. And that's our opening. No standard car charger produces interference capable of disrupting common area security systems. It's a claim so far-fetched, it's evidence of bad faith enforcement. He paused, gathering his notes. Here's the thing, Ethan. People like Gerald Thorne don't risk community funds on a fight they can't win unless they have a personal motive. The HOA's legal fees alone could wipe out their operating budget for the year. This is about power or money, or both. Dan assigned Ethan homework. While I'm filing our opposition and demanding preliminary discovery of their board meeting minutes from the last 6 months, you need to be a good neighbor. Talk to the other residents. Find out what Gerald's obsessed with right now. Is he running for re-election? Is he selling his house? Is there another big community project he's pushing? Ethan spent the next 2 days walking Azure Cove, a community he had previously only seen from the driver's seat of his silent electric car. He started with Eleanor Vance, an 80-year-old resident rumored to be the unofficial historian and keeper of all HOA gossip. He found her tending a magnificent patch of hydrangeas, a shade of deep purple that was, Ironically, probably non-compliant. Oh, Gerald Thorne, Eleanor sighed, clipping a dead bloom with surgical precision. The man thinks he's an emperor. He drove off 3 good board members last year, including my dear friend Harold. They disagreed with his financial priorities. What kind of priorities, Eleanor? Ethan asked gently. He's been obsessed with getting rid of the greenbelt. You know, that little strip of land by the back gate that runs along the canal? It was designated as common area recreational space. Hasn't been used in years, but it's ours. She lowered her voice and looked around nervously. Harold said Gerald's been pushing the board to rezone it and sell it to a developer. Ethan's mind raced. Sell it? Who would buy a narrow strip of wetlands? A high-density luxury townhome developer called Prestige Crest. Apparently, that strip is the missing link they need to connect their new project to the main access road outside the gate. Harold said Gerald's been having private meetings with the developer's lawyer, a woman named Ms. Alcott. Eleanor looked at Ethan, her eyes suddenly sharp. Gerald wants to use the money from the sale to finally install those tacky granite monuments at the entrance he's always wanted. Harold called it selling the soul of the community for a tombstone. That's why he resigned. The pieces clicked into place. Gerald wasn't worried about fire risk. He was protecting a massive multi-million-dollar land deal. Ethan returned to Dan's office, slamming his notebook on the desk. I found it. It's not about the charger. It's about a land deal. Dan looked up from his computer, a look of focused intensity on his face. Tell me everything. Ethan recounted Eleanor's story. The green belt, the secret negotiations with Prestige Crest, the developer's need for the access road, and the resignation of the former board member. Prestige Crest. I know them, Dan murmured, his fingers flying across the keyboard. They have deep pockets and a reputation for aggressive land acquisition. This makes sense. If Gerald is trying to sell community land, he needs the board to appear perfectly in control, perfectly united, and absolutely intolerant of any deviations from the CC&Rs. You, Ethan, with your shiny Tesla and your state-level statute, are a visible sign of dissent. You represent a legal precedent that could complicate the land sales due diligence and potentially expose Gerald's overreach. He pulled up the HOA's lawyer's website. Sterling, and Pierce. Their senior partner, Ms. Alcott, specializes in real estate and zoning acquisitions. She is the developer's main lawyer. Dan looked at Ethan, the professional mask slipping slightly. Ethan, we are not fighting the HOA. We are fighting a multi-million-dollar land development firm. This injunction hearing is just step 1 in clearing the path for their road. The stakes had just launched from a property squabble to a conspiracy. So, what do? We can't prove the land deal in 2 weeks, Ethan said, feeling the pressure mount. No, but we can imply bad faith, Dan replied, a slow, dangerous smile spreading across his face. We're not going to mention the land deal in court yet. We're going to use it to frame Gerald's behavior. We argue that the HOA's actions are prima facie evidence of selective, unreasonable enforcement, driven by ulterior motives that have nothing to do with fire safety and everything to do with silencing dissent. Dan worked through the night, meticulously crafting their response. They focused on 3 key areas. Legal supremacy. The state statute overrides the CC&Rs on this specific issue. Lack of harm. The charger is concealed, inspected, and poses no threat. Bad faith. Highlighting the invented claims, EMI, fire hazard, and the extreme disproportionate financial penalty, $45,000 demand, as evidence the HOA is acting with malice, not good faith governance. The night before the hearing, Ethan stood in his garage looking at the wall connector. It was just a black box, humming quietly, connecting his property to the future. Tomorrow, that box would be Exhibit A in a case that might cost him his savings, but could also expose the deep corruption rotting Azure Cove from the inside out. He dressed meticulously the next morning. It wasn't about looking rich. It was about looking respectable, reasonable, and wronged. Dan picked him up exactly at 8 a.m. They drove in silence, reviewing the final talking points. Stick to the facts, Ethan, Dan instructed. Let Gerald look like the petty tyrant. We are the voice of reason and the law. They arrived at the courthouse. It was a massive, intimidating building of gray granite, the kind of place where principals were stripped down to paperwork. As they approached the security entrance, Ethan spotted Gerald Thorne. Gerald was standing near a marble column, his navy blazer immaculate, his expression smug. Beside him was his lawyer, an older man with silver hair and an air of detached superiority, but there was a third person with them, a woman in a perfectly tailored charcoal power suit, her demeanor radiating quiet authority. She was Ms. Alcott, the high-powered lawyer from Prestige Crest, the developer buying the Greenbelt. She wasn't just standing near them. She was leaning in, speaking quietly, her hand resting briefly, familiarly, on the shoulder of the HOA's lawyer. The three of them laughed, a brief, sharp sound that echoed in the cavernous hallway. They were united. Gerald, the HOA's lawyer and the developer's chief counsel. Ethan stopped dead in his tracks. Dan followed his gaze, his jaw tightening as he recognized Miss Alcott. The friendly, professional facade he usually wore evaporated, replaced by a look of sheer, cold fury. "Well, I'll be damned," Dan whispered, his voice dangerously low. "They didn't even bother to hide it. She's here to watch, but she's also here to signal their backing. The HOA's lawyer isn't their primary counsel, Ethan. He's just the puppet. We're about to walk into a hearing where the developer is paying the bill." Dan adjusted his tie, suddenly radiating a new fee. Courtroom B was a temple of muted tones and cool efficiency. High ceilings, dark oak paneling, and an air conditioner that perpetually hummed, lending a false sense of calm to the high-stakes confrontation. The room was sparsely populated, Ethan and Dan on one side of the plaintiff's table, facing Gerald Thorne, the HOA's lawyer, Mr. Sterling, a man whose tailored suit seemed to contain more starch than his spine, and two other silent, terrified board members who clearly wished they were anywhere else. Ms. Alcott, the developer's counsel, sat discreetly 3 rows back, her expression unreadable, a powerful shadow cast over the proceedings. Presiding was the Honorable Roberta Wells. Judge Wells was known for her impatience with pettiness and her absolute respect for the written letter of the law. She sat high on the bench, her reading glasses perched on the tip of her nose, looking over the hefty stack of briefs. She did not look impressed. "Mr. Sterling," Judge Wells began, her voice a low, resonant gravel that commanded attention. "The court has reviewed your motion for a preliminary injunction. I confess I find the severity of the requested remedy, the forced entry and removal of an internal electrical fixture, to be, shall we say, extraordinary in a community dispute. Please enlighten me as to the irreparable harm your homeowners are currently suffering." Mr. Sterling rose, smoothing his silk tie with a nervous hand. He had the voice of a man accustomed to addressing subservient HOA committees, not a seasoned judge. "Your Honor, the harm is twofold. First, the aesthetic integrity of the Azure Cove community has been compromised by an unauthorized permanent internal structural modification, the wiring, violating Article 7 of the CC&Rs. Second, and critically, Mr. Cross's installation of this high-capacity battery charging station creates an unmitigated fire hazard and the potential for electromagnetic interference with critical common area infrastructure, directly endangering our residents and their property values. Sterling called Gerald Thorne to the stand. Gerald, smug and emboldened by the formality of the setting, took the oath and settled in. He spoke in the tone of a community patriarch betrayed by a young rogue. "Mr. Thorne, can you explain the community's concern regarding this installation?" Sterling prompted. "It's simple, Your Honor," Gerald declared, addressing the judge directly. "Azure Cove is a community built on uniformity and shared risk. Mr. Cross unilaterally installed a powerful experimental device that frankly scares the neighbors. These batteries catch fire. We asked him politely to remove it and submit plans, and he refused. His defiance, coupled with the danger he introduced, forced the board's hand. We are merely seeking to uphold the sanctity of our founding documents. And the cost of removing the device? We estimate our initial legal fees alone to approach $45,000 due to Mr. Cross's obfuscation. The risk to the community is unquantifiable. Gerald folded his hands on the rail, looking every bit the weary hero. When Sterling finished, Dan Rhodes rose for the cross-examination. Dan moved with an easy, fluid confidence that contrasted sharply with Sterling's rigidity. He walked straight toward Gerald, carrying only a manila folder. "Mr. Thorne, you mentioned that Mr. Cross's device is experimental and a fire hazard, is that correct?" Dan asked, his voice conversational. "Absolutely. The risks are well documented on the internet." Dan pulled a single document from the folder, Ethan's county permit. "I submit, Your Honor, Exhibit A, the county electrical permit and final inspection sign-off for Lot 207A. He handed it to the bailiff. Dan turned back to Gerald. "Mr. Thorne, do you possess any electrical engineering certifications, fire safety training, or specialized knowledge regarding 240-volt residential wiring?" Gerald bristled. "I am the president of the HOA. I consult with experts." "Which experts, Mr. Thorne?" "Did you consult the county fire marshal's office? Did you consult the certified electrician whose signature appears on this inspection report?" We consulted with our legal counsel regarding the CCNRs," Gerald stammered, trying to steer back to his safe harbor. "Of course, but you levied a fine for fire risk without consulting a single fire safety expert." "Is that accurate?" Gerald mumbled. "It was the board's decision." Dan pressed harder. "You also claim the charger causes electromagnetic interference capable of disrupting common area security. What is the make and model of the security system, Mr. Thorne? And where are the interference readings taken by your community technician?" Gerald shifted uncomfortably. "The board simply received complaints that the system sometimes glitches." "Glitches," Dan repeated, letting the absurdity hang in the air. He walked back to his table and picked up a bound volume of the Florida statutes, placing it squarely on the podium. "Mr. Thorne, are you familiar with Florida Statute 16304? I am familiar with the fact that it does not supersede our private contracts, our CCNRs. Let's review then. Section 163.04 states an association may not prohibit or unreasonably restrict the installation of an EV charging station within the boundaries of a property owner's lot. Is a charging station installed inside a closed private garage with county approval, in the court's opinion, an unreasonable restriction?" Dan wasn't asking Gerald. He was addressing the question to the judge, who was now leaning forward, her eyes fixed on the statute. "It is a clear violation of our permanent structural modification clause," Gerald insisted, his voice cracking with rising desperation. "It sets a terrible precedent. If we allow this, what's next? Solar panels? Windmills? Our community aesthetic will collapse." Dan saw his opening. He walked to the jury box rail, positioning himself between Gerald and the judge, dropping the bombshell with quiet precision. "You've repeatedly stressed the sanctity of the CCNRs and the need for reasonable enforcement, Mr. Thorne. Yet the remedies you seek, $45,000 in legal fees and a court-ordered forced entry, are wildly disproportionate to the alleged offense of an invisible wire. Why this extreme escalation?" Gerald attempted a practiced look of injured innocence. "Because Mr. Cross is willful, counsel. He must be made an example of." "Or," Dan continued, his voice hardening, "is it because Mr. Cross represents a potential legal complication to the Azure Cove HOA's attempts to sell off the community's greenbelt land to the developer Prestige Crest?" The effect was instantaneous and electric. Mr. Sterling jumped halfway out of his chair. "Objection, Your Honor. Relevance! Counsel is introducing unproven inflammatory conjecture." Gerald Thorne's face went pale, his eyes darting frantically toward Miss Alcott in the back row. Judge Wells raised a hand, silencing Sterling immediately. She looked down at Dan, her expression unreadable. "Counsel, you tread dangerously close to speculation. What is the basis for this claim?" Dan met her gaze unflinching. "Your Honor, the plaintiff's aggressive, factually baseless and financially ruinous pursuit of this injunction is evidence of malicious and arbitrary enforcement, designed to eliminate a challenge to the board's authority before they proceed with the multi-million-dollar sale of common area property. The HOA's legal counsel is clearly working in tandem with the developer's counsel, who, I note, is sitting in the gallery right now. Dan gestured toward the back, confirming Ms. Alcott's presence. The judge's gaze snapped from Dan to the charcoal suit in the back row. Ms. Alcott quickly looked down at her phone, suddenly deeply interested in the marble floor. Judge Wells didn't miss the exchange. She slowly removed her reading glasses and set them down. She leaned back, staring directly at Gerald, who was sweating profusely under the courtroom lights. "Mr. Thorne," the judge said, her voice completely stripped of warmth. "Did the board consider the state statute regarding EV charging stations before pursuing this litigation?" "We considered our CC&Rs, Your Honor, which are private contracts." "Answer the question, sir. Did you read and formally consider Section 163 or 04? "No, Your Honor. Our counsel advised that our documents take precedence." The judge turned to Mr. Sterling. "Counsel, did you advise your client to disregard state law regarding EV charging technology?" Mr. Sterling, visibly shaken, stammered, We advised the CC&R's provision on structural changes was the more narrow and applicable authority." Judge Wells inhaled slowly, a gesture of profound disappointment. She spent a long moment looking at the ceiling, then down at the motion for the injunction, and then finally at Gerald Thorne. She lifted the motion document high in the air, holding it between two fingers, then let it drop to the bench with a sharp, decisive thwack. Then it happened. The corners of Judge Wells's mouth twitched. A low, breathy sound escaped her, a sound of sheer, incredulous astonishment. She covered her face with one hand, her shoulders beginning to shake uncontrollably. It wasn't angry. It was a pure, unadulterated fit of professional mirth. The judge was quite literally stifling a laugh. She took a shaky breath, finally looking up, her eyes watery with repressed amusement. "The motion for a preliminary injunction is denied," Judge Wells announced, her voice still laced with a final lingering rumble of laughter. "The plaintiff, the Azure Cove HOA, has failed spectacularly to prove either irreparable harm or a substantial likelihood of success on the merits. Their claims of fire risk are contradicted by the county's own certified inspection. Their claim of aesthetic violation is impossible, given the installation is inside a closed garage, and their claim of electromagnet. The order arrived in Azure Cove's mailboxes on a Tuesday, not in a gold-embossed envelope, but as a plain, certified letter from Dan Rhodes's office. It contained a single brutal attachment, a copy of the Honorable Roberta Wells's final order denying the injunction. The community hadn't cared about the charger. They cared about the price tag. The moment the residents saw the line, "Plaintiff, Azure Cove HOA, ordered to pay defendants reasonable legal fees," the apathy evaporated. Replaced by a scalding wave of financial fury, Gerald Thorne hadn't just lost. He had lost on the community's dime, funding the defense of the very man he'd tried to crush. The HOA's operating reserve was healthy, but $45,000 was a catastrophic blow, requiring a significant one-time assessment, a direct tax on every single homeowner in Azure Cove. The neighborhood, normally silent except for the chirping of lawn sprinklers, was buzzing. Whispers turned into furious phone calls. The question wasn't why Ethan wanted a charger, but why Gerald had spent the equivalent of a new roof on a case the judge had deemed arbitrary, capricious, and deeply unreasonable. Gerald Thorne, a man who believed crisis management meant simply denying the crisis, called an emergency community briefing for Friday night in the clubhouse. The notice, posted with only 3 days' warning, was a clear attempt to control the narrative and, more urgently, to push through his real agenda before the rot of his legal defeat spread too far. Ethan met Dan at a coffee shop far outside Azure Cove. Dan was already grinning. "The fee schedule went in this morning. Certified. We charged them exactly $42,500. It's reasonable, verifiable, and excruciatingly expensive for them," Dan said, sipping his coffee. "But the fight's not over. Gerald's going to use the loss to cry poverty, then leverage the windfall from the Greenbelt sale as the solution. He'll try to tie the two together. Suffer this assessment now, but get rich later." "If he sells that land, it's gone forever," Ethan countered. "And the land deal, that's the real reason he sued me, not the charger. He needed me silenced before the deal closed. The injunction was just a quick kill attempt." "Exactly. So we stopped the land deal. HOA law mandates a community-wide vote to sell common area property. Gerald is rushing that vote. We have 72 hours to turn 30 years of apathy into an organized revolt. Ethan felt the familiar thrill of the chase, the kind he used to get when he was pitching a desperate last-ditch software upgrade. This was politics, messy and visceral. His first stop was Eleanor Vance. He found her on her back patio, looking over the greenbelt, a strip of mature trees and wild sawgrass bordering a narrow, muddy canal that served as a natural buffer from the outside world. "It's a disgrace, Eleanor," Ethan said, gesturing toward the peaceful, overgrown space. "He wants to pave this, put in a road for Prestige Crest, and fill the community coffers with money that will only line his pockets and pay for granite tombstones at the entrance." "He is the king of misdirection," Eleanor said, her voice sharp with clarity. "He knows the truth is in the ledger, Ethan. Harold, the former board member, always said Gerald's personal remodeling company received an outsized number of bids for common area maintenance. Fencing, pavement sealing. He's been skimming for years. The Greenbelt sale is his retirement fund." Ethan nodded. "Dan is demanding a forensic audit, but that takes months. We need to win the vote first. We hit him with the two things he can't refute: the judge's public humiliation and the fact that he tried to sell our shared history for his own gain." Ethan spent the next 2 days creating a presentation, not for a courtroom, but for a neighborhood watch meeting. He printed hundreds of flyers using large, bold font. The headline was simple: $42,500. What Gerald Thorne spent to lose a fight about a wall socket, and what he's selling next. Friday night, the Azure Cove clubhouse was overflowing. Folding chairs lined the walls. People stood 3 deep in the back. The atmosphere was less a community meeting and more a vigil on the eve of a battle. Gerald Thorne took the stage, flanked by his 2 silent, terrified board members, Carol and Robert. He started with his practiced presidential gravitas, but the tremor in his voice betrayed his panic. "Friends, neighbors, let us be clear," Gerald began, trying to project authority. "Last week we suffered a minor procedural setback in a highly technical legal venue. The courts were distracted by semantics, but the principle remains. We must protect our CC&Rs. Yes, we incurred legal costs." A man in the back shouted, $42,000, Gerald." The crowd erupted into furious murmurs. Gerald slammed his gavel. "Order! That amount is provisional. We are appealing! But we have a solution." He pivoted, pointing to a hastily printed aerial map tacked to the wall, a garish red line slashing through the greenbelt. The sale of this unused, mosquito-infested strip of low-utility land to Prestige Crest will bring an immediate one-time payment of $1.8 million into our community. This windfall will not only eliminate any temporary assessment needed for legal fees, but it will allow us to finally install the security gate upgrades and, yes, the beautiful granite monuments that this prestigious community deserves. He stepped back, waiting for the applause. It didn't come. A strong, clear voice cut through the silence. "Mr. Thorne, I have a question." Ethan Cross rose from the front row, his posture impeccable, his voice calm, cutting through the anxiety like a knife. He held a thick binder. The judge found the board's actions to be arbitrary and capricious. "You swore on a witness stand that my charger posed an unmitigated fire risk and interfered with the security system. You lied. The county inspector confirmed the installation was safe before you sued me. You risked community funds on fabricated evidence." Gerald's face flushed a deep crimson. "I will not tolerate slander, Mr. Cross. That matter is closed." "It is not closed, Gerald," Ethan shot back, raising his voice slightly. "Because your actions in court, the frivolous lawsuit, the fabricated risk, prove you are acting in bad faith. And this land sale is the reason why." Ethan pulled out the flyers he'd printed. Dozens of homeowners prepared by Eleanor began distributing them through the rows. Prestige Crest needs that land for access, and they are paying you a handsome kickback through excessive legal fees and, I suspect, other means to push this through. Why the rush, Gerald? Why the sudden, unscheduled vote on a massive, irreversible land sale? Because you know that once the public knows the truth, your scheme falls apart. Carol, Gerald's board loyalist, stood up, her voice shrill. This is a witch hunt. You're just angry because we tried to enforce the rules. Enforce the rules? Eleanor Vance, frail but formidable, stood beside Ethan. You spent $42,500 of my retirement money to lose a fight against a wall plug. I demand to see the minutes detailing Gerald's private meetings with Prestige Crest lawyers. I demand a full independent audit of the maintenance contracts he's awarded to his own company over the past 5 years. The clubhouse exploded. People were shouting, demanding answers, waving the flyers detailing the lost legal fees. The momentum had shifted completely. Gerald had lost control of his own community. Gerald Thorne backed into a corner, finally cracked. He gripped the podium, his knuckles white, his veneer of composure gone. "You people are unbelievable!" Gerald shrieked, no longer addressing them as neighbors, but as subjects. "You whine about a few $1,000s, but you refuse $1.8 million that will modernize this entire community. I am doing what is best for Azure Cove. I am the only one who cares about the value of your investments, and I will not let this spoiled brat with his socialist car and his lying lawyer destroy everything I've built." Ethan saw his chance. Gerald had just confirmed the core conflict, his power against the community's self-interest. Ethan walked up to the podium and placed a large, clipboard-sized document next to Gerald's hand. It was a formal, legally drafted petition for board recall. "Gerald," Ethan said, his voice now calm and utterly devastating. "The judge laughed at you in court. Tonight your neighbors laugh at you in this room. We are putting the fate of the Greenbelt and the fate of this community into the hands of a new board. Right now, we don't need to appeal your loss. We need to remove your tyranny." He turned to the crowd, holding up a pen. "If you vote no on the Greenbelt sale, and if you demand an independent audit, you must sign this petition to remove Gerald Thorne and his board immediately. Stop the sale! Stop the bleeding!" Eleanor Vance was the first to step forward, signing her name with a flourish. A line immediately formed behind her. The scratching of pens on the petition became the loudest, most resolute sound in the clubhouse. Gerald Thorne stared at the pen in Ethan's hand, then at the growing line of furious homeowners, his eyes wide with a look of pure, agonizing realization. The battle for the wall charger had been a distraction. He was losing his entire empire to a petition drive. He lunged for the microphone, shouting a desperate final threat. "You will regret this. You will all regret this when Prestige Crest starts building the road through your precious Greenbelt anyway. I still have the proxies.